Hello, everyone. Welcome to our first webinar. We were thinking about doing a webinar for a little while, but the unfortunate situation of the coronavirus propelled us to do it as soon as possible. So we're starting today. And, Rita, can you remind too, please? When you get it to, we're also drinking coffee, and we're doing this from home like everyone's going to be doing, which is going to be working from home soon. So for a little while at least. So we're trying to get excited about that, get everyone excited about that, and try to give people some content that obviously has little to do with the coronavirus and has to do with today. We're going to be discussing how to clean up your criminal record. And we're going to talk about mostly expungements. Thank you. And we're going to also talk a little bit about other types of ways to have your record cleaned up, like maybe a little bit of discussion about pardons, both state pardons and federal pardons. And we're going to talk about Prop 64 dismissals. And I have here with me William Figueroa.
Good morning. Hello. My name is William Figueroa, and I'm an attorney for California Rural Legal Assistance. It's a nonprofit law firm that has 18 offices statewide, and we do various services to the low-income community. One of the areas that we've gotten into recently is the reentry expungement service area, because a lot of people have prior convictions and it's holding them back from getting a better job. It's affecting their applications for housing, and it's kind of important because of all the people nationwide who are eligible for some kind of post-conviction relief. Only 6% are taking advantage of those statutes and those laws, which would help their situation. So that being said, we're kind of going to do a general overview of what they call reentry. And it was called reentry because it's for people who are leaving the criminal justice system and reentering society. So first and foremost, what is an expungement? An expungement is basically when the court orders a conviction to be set aside. A plea of not guilty will then be entered, and then the complaint is dismissed. So basically, there are specific requirements to be eligible for expungement. And the best way to determine...
And by the way, guys, we're doing California today. We just want to...
Oh, that's true. Yeah.
We're doing California, but if anybody has any questions, I see we have some questions on Instagram. I'm going to get my daughter to hopefully read those to us so we can respond. But if you guys want to talk about other states, even though we're not licensed to practice there, you can always email us. Maybe we can give you some information about it. But we're going to be talking about California mostly and some federal things. So we're starting with California expungements.
So basically what we say, the first step would be get a copy of your record. If you have convictions only in one county, let's say like Los Angeles County or San Diego County, you can go to the courthouse, the county courthouse, and get what they call a case report summary. And it's basically a printout. And that would be an important first steps, because that usually lists all the activities you've had on probation. It'll show any violations of probation, but hopefully it'll show that those violations were reinstated. And then it'll show whether or not probation was terminated successfully. And that would be a good way to know that that's possibly a case that you can get dismissed off your record. If there's out-of-county convictions from, let's say, Los Angeles, you can obtain a record of arrest and prosecution sheet, also known as a rap sheet, like they say in the TV shows. There's a couple of ways to do it. There's a Department of Justice application to get a copy of your rap sheet. I think there's...
And that's probably for right now. The next thing that Bill's going to talk about is something you have to do in person, which normally I think is the better idea. But given kind of what's going on right now, this first way might be the best way, which is to write into the Department of Justice.
Yeah. The other thing
is... Do you have an address, or what is it?
It's a website, and they can look online. The form for the fee waiver is BCIA 8690, and it's a form you can download. The other thing is there's an organization or a company, I guess, called LiveScan. And they're like a company that will run your rap sheet for you. Usually they're at events like community clinics and stuff like that, or maybe some nonprofit organizations in your area will be able to help you with that.
Or you can just Google live scan. Also, it might be possible. Maybe they can come to your house to take fingerprints instead of you having to go there. Because right now, considering, you want to just say, thank you. Just maybe just decline it.
Yeah, go ahead.
Yeah. So right now, maybe you can Google live scan your area. This is actually all over the country. And normally you would go there, give your fingerprints. And I would definitely, if you can afford to pay for a rush, if you want to do it quickly, pay for a rush. If you can't, then just do a regular one. But right now, you might want to ask to have people who come to your house and fingerprint you. And a lot of times, I'm saying in my experience, I barely had any clients who've only had cases in one county.
Oh, really? Okay.
So I'm just like, sometimes people might even forget. And I mean, I think it's important for them to have the full rap sheet from either the DOJ live scan in addition to their county thing, because sometimes if you don't know the rest of their record, it's kind of like problematic for them and embarrassing as an attorney. You go into court and you're like, oh, my client only has this one thing. Maybe they have like a violent case from some other county you have no idea about. Right. So it's important to know the full breadth of someone's record. A lot of times people would, like, especially when they were juveniles, maybe it's been a long time, or maybe through psychological repression, they just don't want to think about the thing. So recommendation, go to the courthouse to get all the particulars, because you need that for the expungement, but get the rap sheet too.
So like a statewide report card. Yeah. What about, Allison, if they have like Utah convictions or Connecticut convictions?
Well, I think that they'll get that from the live scan.
Okay.
100%. So when you ask for the live scan, you should ask for the complete one that's like the U.S. Department of Justice. Okay. So we can see everything, just because it's better to see what's going on.
Okay. Now, once you do have your rap sheet, what do you look for? Well, of course, there's certain information that you need to put on the petition for expungement, and the information on the judicial counsel forms, of course, are like the name and date of birth of the defendant, and we're just going to call it the person who has the conviction, the location of the court where you were convicted, the case number, the date and charge of the conviction, and then if you got probation or possibly just jail, you need to know what the sentence was. If you were sentenced to probation, you have to be able to say that you successfully completed all the terms and conditions. If it was a DUI, you paid the fine, you did the first or second or multi-offender program. If you had weekend jail times, you did it, and everything was satisfied.
Including the MAD program, which, by the way, everyone thinks they finished probation that are my clients, and then there's always, they didn't go to the morgue. So, just a little reminder, there's that program that everyone has to do too.
So if you apply for a dismissal of a conviction and they refer it to probation for report, and it comes back and says, well, you didn't comply with the MAD program, they're not going to grant the petition.
But you could try to recall the warrant, if that's in a situation though, if we could pretend, obviously you can have us, if you wanted to hire us to do this, or you could do it yourself, potentially have a public defender assist you. But we call the warrant, get the judge to put you back on probation to finish the program, and then, try to successfully complete. And then what happens though, Bill, if someone has a violation, can they still get it expunged? Let's say you didn't finish MAD, you get put on probation, you finish successfully.
Actually, you can try to have it dismissed in the interest of justice. So there's a certain box on the form. And what that means is
1385, is that the 1385?
No, there's actually on the 1203 section.
Really?
You can say this should be dismissed in the interest of justice. And that's an important point, actually, Allison, because if you have some issue, like you're in the military, you're going to move or be out of the country, that's one example. But if you have like an economic hardship and you can't pay the fine and you needed to get a job, then that's another thing. The interest of justice.
Like saying that you didn't finish paying. Like, so what Bill's saying is that, let's say you're on probation, you have a fine you didn't finish, but otherwise you've completed the terms and conditions. The court actually they can't keep you on probation for simply fines.
Right.
But it also doesn't count as successful completion. So what Bill's saying is that you can still get relief possibly in that situation. Oh, by the way, I just want to show this form here that Bill was talking about. It's the DOJ waiver form. And this is, I think right now, this is like this would be really good to use. So you write into the Department of Justice, which I think, Howard, if you could find us the information on how to write into it later on for people to be able to get this. And then you send this for the fee waiver if you qualify for it. And, given the status of things, this is probably the best way to go about it at the moment.
Okay, so going back to like the interest of justice, we're going to cover other things, but basically the forms encourage you to attach a declaration, like you could write something about yourself. You know, it's important that the judge understand kind of your backstory, why you think you're entitled to get this relief. You could attach reference letters, you could attach certificates of completion of programs and stuff like that. So while sometimes if you have completed parole, probation, and you're not serving a sentence, you've satisfied all the terms of probation, paid all the fees, completed the classes, and you're not currently pending or facing any new charges, basically your petition for dismissal is mandatory. And that means that usually the judge has to sign the petition and order your case dismissed. So those are like the big three to get what they call a mandatory dismissal. And there's like several different statute numbers.
Oh, sorry.
That this, okay.
Oh, so sorry.
This is our first broadcast, so we're a production
I
company.
kind of want to put
still,
this one up too.
oh.
This is what Bill's going to talk about. This is a really important sheet, and of course, if you guys want to discuss this with us further, you can reach out to us on Instagram or through our Margolin Lawrence or any which way to discuss it. But this actually lists here, and we can maybe put up some of these later on for everybody to download. But this lists a bunch of different section numbers under which you can do everything from get relief for cases for which you didn't go to prison through the last, which is important. This talks about cases for which you did even go to prison and the kind of relief that you can get for that. So no matter what your scenario, there may be something for you. There may not, but there may be.
And then there's actually a second page. There's even more, like deferred entry of judgment. 17B is like a reduction of a felony to a misdemeanor. Prop 47, basically.
What's this? This looks really interesting. Okay, so there's a sheet. Let's just go to the second sheet here. And part of what we're discussing today is important. This is going to be as we advertise for both citizens and non-citizens. This first one here, this is very important. This is the first time Bill is showing me this. I didn't know about this section before, this PC 1203.43. Basically, if you get for a drug case in California something called deferred entry of judgment, known as DEJ, PC 1000.
Prop 36, PC 1000.
Well, there was slightly different, right? So PC 1000. Well, all of them. Here's the deal. For all of them, you have to admit guilt in some way. Now, what's kind of, I would say, I don't know, kind of confusing about the DEJ is that for purposes of immigration, it still counts because you're saying, even though the case is dismissed in a DEJ, you're still admitting to being a drug addict, which is actually the basis for removal. Now, so people, sometimes lawyers and other people think, oh, if I get DEJ because it doesn't count for citizens as a conviction, that it's okay. It really isn't. Well, what's very interesting here is that now we seem to have a remedy. PC 1203.43, it says erases a prior deferred entry of judgment as a drug conviction for immigration purposes. A plea withdrawn is considered legally invalid. So that's a really important for anybody who's had a DEJ, has immigration consequences, which is like anybody who's had DEJ is probably in some kind of deportation setting. So that's a really important one. Is that a new one?
It's been around for a while. I think it's been around since we did the Prop 36, the drug diversion things.
Now Prop 36 different. So Prop 36 just is another kind of drug thing. That that's like more like a real expungement because you actually are convicted. And your only relief there on that Prop 36 is an expungement in terms of like that you don't have to tell an employer that you were convicted, but for everything else it counts.
Mm-hmm. But DEJ relief is very important because that's a specific sections and the judges like to check the right boxes. Prop 47 was another law that's passed that basically if you had a misdemeanor conviction, you were reclassified and sentenced. I mean, a felony conviction, you were reclassified and sentenced to misdemeanor. The good news is that you could have gone to state prison on a felony, which usually is an exclusion to getting it expunged. But under Prop 47, you would get reclassified to a misdemeanor, and then usually you would be let out of jail, or it would be what they call terminal. It would be the end of the case. But once it's a misdemeanor conviction, you still need to do a second step, and that's file for an expungement to get the misdemeanor conviction dismissed off your record. And that's a big difference, but because before, if you got a felony and went to state prison, you couldn't get expungement done. Prop 64 was the marijuana resentencing law. Real quickly, it was just a law that made simple possessionary offenses of marijuana and use decriminalized. You could get your case, I think they call it reclassifying.
Well, yeah, so here's the thing, you can get either, and Raza, just my pointers here, and you
Hi,
get the
Roz.
tripods. 2 tripods, that's awesome, Roz, thank you. So Prop 64, so the 2 things that are really important about it, one is that you can actually get old felonies or misdemeanors totally dismissed, or a misdemeanor, and that's kind of why it's going to be interesting to see how the district attorney's offices have actually rolled this out. So like last week or 2 weeks ago, our district attorney, 2 months before the deadline, decided to do a Prop 64 for like 60,000 convictions. But what that means when it, is kind of interesting. So like if you're someone who thinks that maybe you benefited from that, I still think it's important to maybe talk to an attorney, call us, or whoever, but us of course, about checking in on what actually happened to your conviction, because some of them could be reduced. Let's say you had an old cultivation case. The good thing in California mostly, and tell me if this is true of San Bernardino, sometimes San Bernardino is a little bit different, but in LA County, normally when you take a felony plea, they don't make you do a factual basis. And why is that important? So let's say you had 11358, which is a felony cultivation conviction from a long time ago. Let's say it was like 20,000 plants. Well, in LA, if there's no factual basis convictions, that means that the plea is simply to cultivation. And under the law, cultivating less than 6 plants now is not a crime. So that kind of case, you could get totally dismissed if you don't have a factual basis plea. So there's things that like a defense lawyer probably may understand better than the DA's office. And if you're someone, like I said, who thinks you may have benefited, call us. One thing that's important too, and I was just looking at this, is that Prop 64 so far has been determined not to be able to get rid of convictions for purpose of immigration, and you might need other relief. So we just did a case, similar to that. And this 1203.43 may be useful, and also maybe 1385. And that case is on appeal right now, whether or not 1385 dismissal is enough. Rosa, do you want to jump into our scene here? We just had the arrival of my law partner, Rosa Lawrence, and he is now joining us here. He also got the tripod for us, so we're very excited about that.
Hey everyone, I heard the last part of that discussion about these automatic reductions that have been going on under Prop 64, and that's a very positive thing. They really cleaned up a lot of people's criminal records, but no one should rely on this automatic process, because there's a lot of subtleties that a lawyer looking at the situation could help you figure out and possibly get a better result. Like Allison mentioned, there's a lot of cases that could be totally dismissed under the new law that the system wouldn't catch, and instead it may have reduced it to a misdemeanor, which is great, but you should go for the dismissal if you can. Also, a lot of these situations, if you have any unique circumstances that make you sympathetic, like immigration situations or problems with your job, a lot of judges are willing to give you a break if they can see that you've really cleaned up your act, and you'll go above and beyond what the automatic process would allow, and grant your dismissal in the interest of justice. There's something called nunc pro tunc that makes it date back to the original conviction, and good things can happen if you just hire a lawyer, go into court, and just discuss your situation, and you never know what you can happen. But
especially immigration is super important, because so here's the thing with immigration. Normally, I would say a citizen or someone, let's just say a naturalized citizen who wants to try certain things on their own, I recommend, if you don't have money, or you do it, or if you get the post defender, even better. But for a non-citizen, if you go into court and start even mentioning immigration on the record, the immigration court can look at the entire transcript, and if there's evidence that this is done because of immigration, consequence, or anything like that on the record, then that can actually be used against you. So you have to be extremely careful.
And that goes with any criminal case. Can obviously have immigration consequences if you're not a citizen, up to deportation. But there's ways to handle criminal cases both before the conviction and after the conviction that can make things a lot better. And like Allison mentioned, if you avoid putting certain things on the record, that can avoid creating a case to deport you. And there's ways to handle the criminal case where you can move it towards certain types of pleas that are okay, that are not considered crimes of moral turpitude, that'll allow you to stay in the country. But you have to handle these very
they won't allow you to stay in the country. Just say it will make you less deportable.
Exactly.
Because really anything over, anything is deportable. Any conviction really is deportable. As of like the 90s, there's.
But in the immigration courts, and when they're deciding what to do, what are the consequences, they're all they can do is look at the record. And if you're careful to keep certain things out of the record that trigger the worst consequences, then you can hopefully move on with your life and eventually maybe even become a citizen.
One question actually, because our next section is later on we're gonna talk about felony reductions, or maybe this comes up later on, but does Prop 64, because this is something I want to confirm, people are gonna ask about this. I think we should do another thing. Can it restore gun rights, Prop 64 dismissal or misdemeanor?
I don't think so, but
So that's something
I know
like
Prop 47 did not. That was
Right,
the one that
Prop
created
47
drug
did not.
possession.
They-
Simple drug possession is
So
not
Prop-
felony.
I
But
think
but it
it's-
said specifically in there that does not restore your gun rights.
I think that Prop 64 may, but there's a lot of, I think maybe our next edition of this may be on gun laws, because I mean a lot of people are buying guns right now. They're very confused about the gun laws.
But the case law actually now in the Ninth Circuit is that if you're a known marijuana user, you have no right to buy a gun. It's you have to fill out a federal form, guaranteeing that you're not a user of marijuana or an addict, a regular user. But if you are a marijuana user and you check no on there, then that's a felony that you've committed.
Well, it depends if you're a user. It
You
depends on
lie,
the question.
yeah.
It depends on the question. So if you ever have a
But
question
if you
about
check
that,
yes, then you won't be able to get a gun and you lose all your Second Amendment rights. So hopefully the law will develop in a way that marijuana users are also able to have their Second Amendment rights and not further discriminated against. But that's just one of the lingering areas where cannabis users still face a lot of discrimination.
now we're getting to the 17b5 later, right? Because that's about you can restore gun rights with the 17b.
Well, we can jump
can we do
right
that
to
one?
it.
Yeah, let's go,
No,
yeah.
it's the next one.
That's cool. So, let's go talk about this. This one, so 17b, which is a form of expungement misdemeanor reduction, that is something you can use to restore gun rights. And Bill, can you talk to us a little bit about that?
Basically, there's certain felony convictions that are eligible to be reduced to a misdemeanor. And basically that's because the district attorney has the discretion to decide whether a certain case should be filed as a felony or as a misdemeanor. And an example is like auto theft, unlawful taking of a motor vehicle.
That's 10, what is that, 10.851?
10851 vehicle, 10851A, I believe.
Yeah.
Let's say you steal a Porsche, well, the DA is going to say, okay, they stole a Porsche. That should be a felony. Let's say you stole a 76 Chevy Nova. Then the DA could say, no, let's file a misdemeanor. That's just like a crude example, but basically they call a case that was filed as a felony but can be reduced or wobbled down to a misdemeanor, a wobbler offense, okay?
And then they call it misdemeanor that can be reduced to an infraction of wobblet.
A wobblet.
Yeah.
Another example of a wobbler that a lot of marijuana people might have gotten or know someone who gotten is maintaining a place for the use of controlled substances. It was meant for basically crack houses, but somehow marijuana got sucked into this law where anyone who maintains a place where marijuana growing and selling are going on can get convicted under this statute, which can be either a felony or a misdemeanor, basically at the discretion of the prosecutor. But if you have one of these, you can get it reduced to a misdemeanor at the very least under the new law, but potentially even get it dismissed altogether if it was marijuana based on the change in law. Possession of concentrated cannabis was another one that was a wobbler, that even one tiny piece of concentrated cannabis was a felony, even if it wasn't for sale. Or could be a felony. It was a wobbler under the past law. Now it's changed to a misdemeanor, but that's another one where if you have it on your past record, you should go into court and see if you can get it cleared up.
Yeah. The 17B reductions are basically discretionary, meaning like under 1203.343 as an example, you can attach letters, declarations, and other types of documents, certificates, diplomas that would be submitted with your petition to reduce it to a misdemeanor. You could also do it as an independent motion, a motion to reduce under 17B.
Now you can do this anytime, just in
right.
terms of kind of form. It's like if you're out there and you're facing this kind of case, there's a lot of like kind of forum shopping, and forum shopping means like the ability when you're in court to try to really gain an advantage by trying things different times in front of different judges. And I'll just give you a little tip. So let's say you're in court and you have this like 10851 or some other wobbler like Laza was describing, which is still a crime actually, that's maintaining a place for marijuana. That wasn't one that was gotten rid of with a Prop 64. Let's say you're in court for that, and depending on the courthouse, but regardless of the courthouse, you're going to have a preliminary hearing, and then you're going to have a trial court, and then there's going to be a post-conviction courts. So you can try, let's say you have a great judge at the preliminary hearing. You're going to want to try your 17B5 at the preliminary hearing, at the end of the preliminary hearing. And the good thing about this motion is you can renew it. Let's say you lose it there. Then you get sent to a trial court. You can try again. Let's say you go to trial, you get convicted. You can try again. Let's say you're on probation. And then, well, let's say you're off probation. You want to go back for post-conviction relief. Well, then you're going to probably get another judge because that judge is going to be whoever. There's usually a judge assigned to the courthouse that does post-conviction relief. Or maybe the courthouse, it goes back to the same judge. So all that kind of what judge you're going to get and the politics of the judges, that's really important in evaluating, these kinds of motions. And that's something that a, experienced lawyer in that locality can help you with too. But the good thing about 17b5 is one you can try many times.
Right, and that's true with all the expungement petitions.
Yeah.
There's no limit. In fact, since we've been doing expungements in my office, we get rejections from the clerk, and either they didn't have the correct conviction date or they checked the wrong boxes. I think there's up to 7 different boxes on the 1203 point, or the 1203 petition for dismissal. So you have to be sure to check the correct thing. Lastly, real quickly, depending on the conviction, I believe, you may be able to use the 17B to restore your gun right, but it's a case-by-case review, and it's just another option under 17B.
And the reason for that is under the law, once it's reduced to a misdemeanor, it's like it was a misdemeanor all the time from the beginning. So
But
it's really like you never had a felony on your record.
Except there's a couple different exceptions to that. One that just comes to mind, giving an example, is there's some felonies that are strikes that even if they're reduced, they're both strikes, which means that they're serious or violent offenses for which you can go to prison, and they also have other collateral consequences. But those crimes, some of them, a couple of them, can be reduced to misdemeanors. So those crimes, for example, even if they're reduced to misdemeanors, you'll never get your gun rights back unless the law changes. And examples of that would be a 459 residential burglary. A 459 can be reduced to a misdemeanor, but because if a 459 can be a felony, plain, it can be a felony strike, and then it can be a misdemeanor. As a felony strike would be like a residential burglary. A non-felony strike would be like a commercial burglary of something over $900. So the instance of a commercial burglary over 900, the 17b5, that's going to still be a 459, but a non-strike. Or maybe it'd be a different kind of burglary, but that could be reduced to a misdemeanor. You get your gun rights restored. Residential burglary, you could get it reduced to a misdemeanor potentially, but you're not going to get your gun rights restored. Same thing with 245, which is an assault with a deadly weapon. And that's one that can be a felony. It can be a felony strike, or it can be a misdemeanor. So, I think no matter what the ADW is, if it's a felony, you'll never get your gun rights restored. So this is a very case-by-case basis, and you need, experienced person to tell you. But there may be opportunity, but it's also good to know, obviously, what you can't do. So.
Okay, real quickly, we talked about discretionary dismissals in the interest of justice. We talked about 17B, and then one of the other things was Prop 47. I guess it was in 2014, the voters of California passed Prop 47, so the crimes like drug possession and petty theft related offenses were reduced from felonies to misdemeanors. I had clients when I was a public defender who were sentenced to 3 years in prison. November 4th, 2014 came along, and they literally got resentenced to misdemeanors and released from state prison. It was retroactive, which means that if you had a prior conviction that was eligible, they would reduce it to a misdemeanor. That is important because once it's reduced to misdemeanor, you can do the expungement. So it's kind of like a 1-2 punch for people who had certain felony convictions. Examples of offenses are like second-degree burglary. And I believe, Allison, it's like a $950 value of the items you stole.
That was what we were just discussing right there. We were saying, so like the first one, second-degree burglary, which is 459, so that's the same section as residential burglary. But in the commercial burglary, that's reducible, and you'll probably get your gun rights back, whereas if it's residential, you won't.
And that's usually like a shoplifting where you went into a building to steal something like Walmart. The problem I saw was that you have to prove that the value of the item you stole or the value of the property involved in your conviction was less than $950. And
you have to prove that yourself, you mean?
Well, in Ventura County, I became rudely aware of that, believe me. Yeah, so basically what
normally, in criminal cases, there's no burden on the defendant to prove anything, by the way. That's why we're like shocking. So what's the deal in Ventura?
They say that it's the burden of the petitioner to
God.
prove that they're eligible, just like they have to prove they completed probation and all the other terms. So that's something to think about. And then again, if you have any questions, like Allison and Raza said, consult the immigration attorney if there's issues regarding your citizenship or your documentation for citizenship. And then if you have any other questions, just consult an attorney. And then lastly, the good point of information is usually the public defender's office. Similarly, that brings me another point. If you were convicted and represented by a public defender, then you should call their office and talk to them about something else. Real quickly, Prop 47.
Did we do the offenses yet, by the way? Should I put this up again? Because these are really important. I mean, we can obviously, we'll put this up later, but this is a list of all the offenses that are reducible under Prop 47. One you may not have known about is forgery. That's like, when I started my criminal defense practice in 2002, all my first cases were forgery, meth, credit card access fraud. That was like during the big meth days. So I know that I had a lot of clients
drug addicts end up committing forgery because they're committing some kind of crimes to maintain their addiction.
And that happened. That was a popular crime in the early practice. So I know there's a lot of people out there who have these convictions for the PC 470 that definitely would want to have those reduced, and that could restore their gun rights. That's a huge one. So forgery, that was like I said, when I started, all my first cases were in the Torrance courthouse, and I represented all these different meth rings. And probably forgery was the #1 most popular crime of my clients in the office at that time. So I think there's a lot of people out there
receiving stolen property. That's another
That's
one.
one.
A lot of drug addicted people end up.
And simple drug possession.
Shops. Yeah.
And then simple drug possession. If you ever, like before 2014, got convicted of possession of heroin, possession of cocaine, any kind of possession of any drug was reduced to a misdemeanor. And this was huge, obviously, in our state. And this was.
Now, what about the issue of transportation of controlled substance? A lot of people had felony convictions for transportation. It didn't say for sale or not for sale.
That's one we have to retry that one. This is one that you would, if you have a transportation, and you can show it's for personal use. That's kind of, the level of which you have to show we'll discuss. That's
The
one that
Costco defense, where you caught with the high quantity, but it's all yours.
Well, it's also like, what if Well, also, the other thing was,
The Costco defense.
But they changed the sale. They changed the law where now it has to be transportation for sale.
That's another thing
But it
too.
used to be even transportation for personal use.
So that's the deal. So Roz is saying this very interesting thing. So a few years, if you have an old transportation case from before 2014 or so, the law changed in two ways. One is transportation became established, although I think the law always was this, but it became, let's say it was articulated now that transportation required to be for sale.
But the law, there was actually case law saying even if you have one just personal use amount of drug and you take one step or you ride your bike half a block, that's transportation.
But now it changed.
It's a felony.
So
that changed. So if you have an old transportation case, we may be able to get that reduced to a misdemeanor under Prop 47, because you can show that the old law, just by the fact that the old law allowed sales, that already may be used to invalidate the conviction. So there's a lot of things we can do with old drug sales, not necessarily sales cases, 11 through, but here's the good thing too. Drug sales and drugs transportation sometimes under the same section, depending on the thing. So like marijuana, 11,360 is transportation or sales. Methamphetamine, is it the same 11,378?
I think so.
Is the same possession for sale and transportation. So there's a lot of drug. I know with crack sale 11,352, that's transportation of crack cocaine.
But let's say even if it was for sale, a lot of times
it's the same section. You won't even know the difference.
Right. Even if you did have it for sale, the record of conviction might not say that.
That's
it might just say transportation. So
that's what we're trying to say. That the same section.
Looking at it and going and seeing, give it a shot, see if the record's ambiguous enough, you might be able to get it dismissed even if there was sales.
Exactly, because normally, like we said, in many courthouses, especially in LA County, but many places, there's no factual basis, especially if you have a decent lawyer. Anybody knows, if you have the ability to not have a factual basis, most lawyers just plead just that it's in best interest of the client. Right. So in those scenarios where it's the same offense for transportation or sales, and the record is unclear, that's a place we might be able to get you out of the whole situation. So it's worth a try. If you don't try, it's not going to happen.
Right, and Prop 47 is important because even if you got a felony and were sentenced to prison, you still may be able to get expungement from the misdemeanor if it was reduced.
Except one big thing about gun rights. Prop 47 does not restore
your gun rights. That's correct. So you're still a prohibited possessor. And you don't want to have a felony conviction after you got your cases reduced and dismissed.
Now, there are other things you can do to restore your gun rights, like a governmental pardon by the governor of California, or if you have a federal situation of federal pardon.
Are we going to get into pardons and certificates of
Well,
rehabilitation?
that might be for next time, but we're just discussing it brief. Like, do you want to add something about the certificate of rehabilitation?
Or just say what they
Yeah,
are.
say what it is.
Well, that's it. So
Yeah.
if some people are not eligible for expungements or for 17B reductions, let's say you got convicted of a felony and you got sentenced to state prison, then you're not allowed to do an expungement even when you're
Well,
off
we have
parole.
one thing that you could.
But if you get convicted of a felony and you get probation, you successfully complete probation, then you can do the expungement. But if you got state prison, you're never able to do the expungement. But you can do a certificate of rehabilitation and then a governor's pardon, and those can be very useful. Both if you have a felony to essentially clear up your record on that, even if you went to prison, you have to wait usually a certain number of years where you've been crime free. And then the district attorney's office will have a chance to do an investigation looking at your employment history, your friends and family, basically looking at your whole life. And if they think that you've lived a clean life and you're reformed, then they'll grant you a certificate of rehabilitation. And that can be a way to move on with your life. Now, if you're not eligible for the certificate of rehabilitation.
How would you not be eligible?
Well, if it hasn't been enough years.
7
Okay.
years after parole, isn't that the one?
It's like 10 now.
10 years now?
It depends on what the crime is.
Okay.
It's 7 to 10 years. But there's a separate act where you can get a governor's pardon
Right.
if you're not eligible for the certificate of rehabilitation. Or even if you do get the certificate of rehabilitation, you can then also get the pardon. Both are useful. But the other aspect where this is necessary is if you're on the sex offender list, even if it's a misdemeanor
Yeah.
that you have, say you had indecent exposure several years ago, and you have to keep registering as a sex offender. You have that stigma on your record. But if you get a certificate of rehabilitation, you get off the list. You no longer have to register.
That's
You
huge.
can get on with your
That's
life.
awesome. I didn't know that.
Because that
For the person.
being on that registration list, obviously it's publicly available information. A lot of people discriminate against people
Sorry,
on
no.
that list.
And it can include things like we've had people charged, just like as an aside, we can tell you, some of you out there might think, oh, this is horrible. You're saying no. In California, having sex in your car, that could subject you to sex registration.
Right.
That's we've had those kinds of cases. Our clients, of course, we avoided that, but they were originally charged with sex registrable offenses. So there are some things for which it's not right, and people should be able to get off the list. Like many people who had not effective counsel have convictions for sex registrable offenses for when they were like 19 years old and had sex with their boyfriend or girlfriend in a car.
Or a 19-year-old who has dating a 17-year-old.
Right, statutory rape with the 2-year discrepancy, 2-year thing. Let me ask you, Rosa, what is this, and Bill? So when would you be able to use this Penal Code 1203.42 versus needing to have a pardon? Is this for someone who went to prison? I'm just wondering.
This, I think, is AB 109.
Okay.
Yeah, so it's another, I think we covered it real quickly.
Yeah, tell us
So,
about this a little bit.
right.
What is
Um,
so tell us, what is AB 109 and how does that relate to expungements?
well, we're going to get there eventually.
Okay,
So,
okay.
yeah, so we'll circle
Okay.
back to that.
Okay, good.
But that's to be distinguished from Prop 47.
Right. Okay.
Yeah, so real quickly, Prop 64 was the law that made possessionary marijuana offenses and use misdemeanors also. It's
Or no offense. at all.
or no offense at all. You can get dismissed or reclassified as a misdemeanor. That's a separate petition than the expungement, the 1203 petition. And I believe, I think in Ventura County, you have to have a hearing to have a Prop 64
And
petition.
here in LA County, they just did, like we were mentioning at the beginning of the program, that the DA's office just did like 60,000, expungements, but they use like artificial intelligence to do it. So I still recommend if you are in LA and think that you benefited from it, that you should probably go look for your minute order. From the
And
courthouse.
they had some standards where they were dismissing some based on the age of the defendant. It was sort of an arbitrary
Yeah.
cutoff where you fell on one side of the line, you didn't get that special treatment. So it's worth looking at what happened to your case. Look it up. Go to the courthouse. Ask them for a minute order. You can see exactly what
court's
happened
office.
in the case.
Yeah.
And then if you still have something on your record, you can always go back and try to clean it up again.
Real quickly, what cannot be expunged? A conviction where a prison term was served. And this is where it's confusing because remember we said Prop 47 says if you have a felony, you can get expunged. There are only certain felony convictions that were eligible for Prop 47. So if it's a strike, serious or violent felony, or any kind of charge where you had like the sex registration requirement, you can't get it expunged.
Oh, but if it was something you went to prison for that now is not prison offense, you can? Is that the
That's
1203.42?
that's AB 109.
Yeah, so what if it was like that? Let's say you went to prison for like, something that's now a misdemeanor, like a forgery or something. Can you get that expunged?
Yes.
Okay, that's cool.
Okay. And then there's just certain exceptions to what can be expunged. The big ones are the serious or violent felonies, and then any sex-related conviction.
And then that's where you need the certificate of rehabilitation that we just discussed, which you can do if you're not eligible for the expungement.
What expungements will not do is sometimes, depending on the charge, it won't prevent the use of the prior conviction as a prior in a future case. Like, I guess DUIs would be a good example. If you have a second DUI or a third DUI, it increases the punishment for each DUI conviction. It will not stop your obligation to report the conviction if you're trying to get a license for a certain job, for example, nursing or even a school, I think, or jobs in a government office.
But even though that's the case, it's still worthwhile to get an expungement if you're going through the licensing, because to the licensing authority, if they can see that you've had that expunged, that can make a big difference. It looks better, like you performed yourself and you've moved on. So definitely still try to do it even
But don't
if
say
you
you
have
didn't get it.
issues.
But just don't lie on the form, because that one's disqualified.
That's a very good point. The best advice is to always disclose what's out there.
Because an expunged conviction is still a lot better than a non-expunged conviction.
Right. And the other thing is you declare or just, advise them of everything, disclose everything, and then hopefully you have what we call factors in mitigation. Yes, I was convicted of a DUI, but it was in the 80s and everyone was driving drunk in high school and it was a horrible thing, and now I'm a drug counselor and I'm helping people. So that's okay that it's on there, but it's even better if you have something that is like going to help your backstory to show, yes, but it was dismissed. And that goes a long way, especially I do like subsidized housing cases, and it's invariably something that keeps them from getting subsidized housing. They call it criminal activity or convictions. But if they have an expungement, then even the housing authority has to say, they say,
really
wow, okay, normally we wouldn't let people here. And I actually had a case where I looked at a case from New York in the 70s, I think, where a guy had been kicked out of subsidized housing, but he's a counselor, has a bunch of positive things. And the officer who wrote the decision said, in spite of all his past history, including conviction for second-degree murder, I'm going to reinstate his housing. So
is this a federal housing or state housing?
Federal housing, in
That's
both,
awesome.
Actually, yeah. And
that's
that
really
was
good to know, guys. I mean, it's really important.
yeah. So the important thing is, one, he disclosed everything he had, but on the other hand, he had factors in mitigation, and even with a murder conviction, he was still reinstated. So anything's possible. Yeah, and it was a great story. It's one of my favorite ones.
That's a good one.
Let's see. Gun rights will not be restored. It will not seal or erase your conviction from your rap sheet. So like we're saying, it'll still be on your record.
Unless you get the
but it'll be on your record as an expunged conviction. Your rap sheet will show the conviction, and then it'll show that it was expunged. So
I think they say dismissed pursuant to PC 103.4.
Yeah, they call it dismissed.
So it's a dismissal.
It sounds good, but it still shows up.
Right. And then lastly, of course, any sex registration
But that one you can do
conviction.
for that though, like Wazza was saying, you can apply for a different kind of relief called the certificate of rehabilitation.
Right. And then real quickly, we're going to try and get into the forms. Basically, there's 3 basic forms for an expungement. The first one is the CR 180. It's the petition for dismissal. It includes felony reductions, but I would check with the local rules in LA County. The other one is real important, and you want to file is called the order for dismissal. The petition is asking the judge to dismiss your case and stating the grounds why. The order for dismissal is what the judge signs and says, yes, I'm going to grant the dismissal. And then the last one, of course, is a fee waiver. I know in Ventura County, it's $60 to file a petition for dismissal, but we also have a fee waiver, and the judge agrees and signs a fee waiver. They're either going to be mandatory. In other words, you've done the 3 things you need to do, and the judge has to sign the petition for dismissal, or discretionary, which means the judge can consider all the circumstances, your declarations, your letters of reference, and stuff like that, and then it's up to him. Discretionary dismissals are also when you haven't quite completed all the terms of probation. Let's say you still owe fines, but you're in some kind of probationary program where they're trying to help you work off your fines, and instead of actually paying them, they'll give you credit. So there are ways to get your fine suspended and or dismissed, which would then allow you hopefully to get the petition granted. Certain convictions are always going to be discretionary, like vehicular manslaughter and negligent manslaughter and DUI cases, because they have a public safety issue. And then lastly, the supporting documentation that you should provide in the interest of justice can also be attached to the petition. We staple them all together, just the petition, all the supporting
But be
documents.
careful if you're not a citizen. I wouldn't.
Right,
This,
again.
and then you would definitely want to call us for advice before you're like putting together your own packet, because you don't want to have any reference to immigration issues.
Right, and that's like the rule of thumb. If someone, we were screening people for our clinics, and basically the easiest way to do it was say, were you born in the United States, yes or no?
But a way that you can still get that to the court is if you have a hearing, you'd ask to talk to the judge, have a bench conference
Right.
off the record, and you can
Tell them why.
tell them
Yeah.
And
the
say,
reasons, and it won't show up in the record.
Right.
If it's an off the record conversation.
We can tell you guys more about how to finesse that, but it definitely is possible. And we actually even have a law in California that I have to look up the statute that requires the district attorney to take into account immigration consequences.
that's awesome. That's
Yeah,
good.
there's some law like that, and the judges have been pretty.
They also have a policy in
LA.
LA that they're supposed to take into account collateral consequences
Right.
of any conviction, whether that's its effect on licensing and so forth. So even if they act like they're not interested, you can point out, they're actually required under their own policy to consider these collateral consequences, and that a lot of times you can get a reduction if you can show either immigration or employment licensing related that it's going to have some consequence, or it is having some consequence on the record.
So like for their job or their,
Yeah.
Exactly.
So say, if you don't do this, this is really going to
Or if
ruin
you're
my life.
trying to apply for schools,
Right.
you have to list your criminal record.
Hardships. Like
Right.
I had a client
Anything like that.
trying to apply for an internship with the Navy, and he had some DUI convictions and stuff like that. So, I
But
mean,
for all of these ways to clear up your record, it's a good thing if you can point to specific, tangible things where it's going to harm you, whether that's school-wise, employment-wise, licensing-wise, whatever the case. If you can point to an actual real-world problem that your record's causing you, judges are more likely to give you a break and help clear up your record.
real world problem. I like that. The declaration, basically, that's what you're going to say. You're going to make, a compelling story of what's going on in your life. We call it the backstory. You can fill out the legal forms, but if you're going to do it in the interest of justice, what is your backstory? What do you want the judge to read or look at that you're going to give him that's going to say, okay, this is something that I think deserves to be granted.
And that's especially where you screwed up probation to some degree.
Right. Letters from a counselor, an employer, teacher, a pastor, how long they've known you, why they deserve expungement, their goals, what they're trying to do, and how they've changed and stuff like that. How you contributed to society as a volunteer, a parent, your kids are in school and stuff like that. Immigration issues.
Just be careful in those letters. Some people start getting into the facts of their conviction,
Yeah.
go into a lot of details, and you want to be careful that you're not putting things into the record again in the letter that are going to create difficulties, or even admitting to different crimes or new crimes. So it's good to give specifics about the ways you've reformed yourself and to have specific examples, but there's no need to go into a lot of gory details about the particular facts of your criminal conviction.
And then to another point, don't attach too many. We have clinics where clients will bring 10 or 11 letters of reference. We kind of review them and we boil it down to 3 or 4, the top 3 or 4, and then maybe a declaration from them. Because I've had feedback from judges where someone has attached, I think it was 6 letters, and he kind of was mad, said, I don't have time to read all this. This is just a waste of paper, blah, blah, blah. But I mean, it's your call. You don't want to do too many, but on the other hand, if they're all important, then that's your decision. Immigration, like we said, if there's any citizenship issues, contact the immigration attorney before you consider even filing an expungement.
But you can also call Raza and myself, and if you obviously hire us to do this, we will have an immigration lawyer that we consult with about any kind of immigration consequence in any case.
Whatever your immigration problems, it's always worth trying something. There's if you keep trying and persistent enough, you'll find a judge who can help you out.
And the reason why for people who have immigration consequences, so far the public defender's offices and nonprofits haven't been as readily available because you really do have to consult an immigration lawyer on each of the cases. So that's kind of why, unfortunately for people who have that, they kind of need to hire private counsel because you need to be able to then even hire a consult of an immigration lawyer. Honestly, Raza, every time we do an immigration case that involves immigration consequences, like criminal case involving it, we always consult. And it's almost malpractice. I mean, basically not to. So that's why it's a little more complicated.
Somebody's asking if
Yeah.
this is only for California, which you talked about.
Yeah.
Yeah, so far, we'll try and do a nationwide.
Although you just did a little bit on, actually, if you want to go to the previous slide, you just did something on Kentucky versus Padilla, which is,
Oh, yeah,
that's
that was
actually a
the-
federal.
That was
whatever state you're in. If you're listening to this, your state probably has similar ways to clear up your record. It's becoming more and more popular these days to give people a second chance who have a criminal history and criminal justice reforms. So definitely look into wherever you are. If you have a criminal record, there's probably a way you can clear it up through your own state.
And Bill's going to talk actually for a moment right now about a federal case. It's a U.S. Supreme Court case that can be used to actually get relief for people who have immigration consequences all over the country. There's this case called Padilla versus Kentucky that Bill's going to talk about for a moment, and it can create a basis for anyone in the country to withdraw a conviction where they weren't advised of immigration consequences.
Right.
So Bill's going to talk about that for a moment. That's definitely nationwide, any state or in federal court. So Bill, tell us a little about the immigration consequence relief.
Basically, Kentucky versus Padilla was a case where someone was represented by an attorney and they entered a plea, but their attorney did not tell them about the immigration consequences or did not tell them what would happen by him signing this plea. Basically, you must consider whether this expungement will subject yourself or whoever's doing the expungement to immigration consequences. So it's really up to the individual to consult the defense attorney. You could try, or basically the discretionary 1203.43 relief, a guilty or no contest plea is withdrawn and is supposed to have no immigration consequences. In deferred entry of judgment cases, it's kind of the same thing, but except for those two cases, everything else is going to have immigration consequences. And then let's say someone did plead guilty and their lawyer didn't properly advise them, they can try and vacate the conviction if it is shown that their legal counsel failed to advise and defend them against any adverse consequences of them entering a plea.
And if you've got that issue, the best thing to do is
Anywhere.
order the transcript of your plea, and you'll see the court reporter, it'll type out what was said at the time. And sometimes you look at that, it doesn't say anything about immigration, and you can use that then
To set
to
aside
go
your
back.
plea. Yeah. Basically, I was a public defender. I think this law or case came down in 2009. And before we would let a client who was not a U.S. citizen sign or agree to a plea, we had to advise him all that, and he had to initial a box. Because before Kentucky or Padilla versus Kentucky, there were a lot of people who took a deal and then they were deported or something happened and no one ever told them.
Yeah.
So it's, as lawyers, it's important that we discuss your immigration consequences. And then as expungement lawyers, it's even more important because that's kind of the thing that's going to determine whether or not you can even, or whether or not you should even do an expungement petition.
But if there's someone out there in any state who pled guilty to a crime and wasn't advised on the record of the immigration consequences, you may have an opportunity to withdraw that plea. And that's a U.S. Supreme Court case, so it does apply anywhere.
Nationwide.
Yeah, nationwide, it applies to all state law and then federal courts too.
Okay. Wow. Real quickly,
We're good. We can go. over
if
it.
you did an expungement petition and you have to go to court, in Ventura County, it's only felonies. I mean, you could do a misdemeanor petition by mailing it in and you don't ever have to go to court. But usually on a felony, there's going to be a probation referral. So you check with the clerk, see if there's a report. If not, the first appearance, the judge will probably refer it to probation and you'll have to come back. When you come back, what you should do is see who the district attorney is in the courtroom and go up to him and say, this is the report. And usually there's a copy for you on the defense table and say, I'm asking what you're going to do. And if it says,
If you're doing it yourself.
yeah, if you're there by yourself, it'll say grant or deny the relief. And usually, because we've done the petition and we did all our probation and we think we deserve to get it dismissed, let's say it says recommend the relief. Well, then the judge has the choice to read it. And usually I'd say like 99.9% of the time, the judge just goes with whatever probation says. So if probation says to dismiss the case, usually even if the DA objects, unless he has a valid reason, they'll grant it. So usually your court hearings are good things. Lastly, if you don't get it granted, you can refile it and you can do it as many times until you get it granted. But the court hearings are kind of, in my opinion, one of the best court hearings they have in our courts, because usually it's someone trying to get something for what they've accomplished. In other words, they finished what they said they do, and they're going to be rewarded by a dismissal. So I used to have clients who would do a petition for, say, I never want to go to that courtroom again. But then when you say, well, if you come, you're going to get your case dismissed, that kind of changed their mind. So the judge will consider factors like the hardship, the declarations, and stuff like that. Real quickly, in housing and expungements, I already talked about it. When you apply for housing, you have to sign a waiver and a release, which kind of is a problem because that waiver and release allows them to get like a level 3 FBI background check. So legislation needs to be passed where the housing from HUD to the local area housing of the county is limited to what they can look into your past. Employers can't go past 7 years, but housing can go back to when you were born and stuff like that. Criminal activity, they can hurt you for having people arrested in your apartment. So if you're considering
Really? Even if someone's just arrested there?
criminal activity is one of the things. And if there's any drug use or manufacture, you're barred. And then of course, like 290, you're barred. And you can have a hearing and challenge their termination or violation notice.
Even in housing court?
Even in the housing, they call it informal hearing at the housing authority.
And where is this? Is that a little federal there? How does that work?
No, well, there's two things. HUD has federal housing and there's certain properties and certain programs. But locally in the counties, they would usually take over the implementation of the federal program. Like in Ventura, there's 5 different housing. There's Housing Authority of Ventura, Point Hueneme, Oxnard. And within those housing authorities, let's say someone is getting housing in Oxnard and they have a Section 8 voucher and they're being terminated because their son, who is in a gang and was released from prison, keeps coming to the apartment and causing problems. They will file a notice of termination or a violation of a lease. And then you have a right to request what they call an informal hearing. And then you have a hearing to see if they're going to revoke the termination notice or go forward with it. And if you don't fix it, the next step is they evict you. So anyway, if you have a criminal record and you're in the public housing area, that's something you need to consider.
Just a related issue for public housing. In the past, the marijuana users have had problems with public housing getting evicted just by the fact that they use marijuana. Now I know there's a lot of people now that it's legalized who are doing it legal pursuant to state law. Are they still having these problems with evictions?
HUD, and this is the bad news, because it's federal, marijuana is a federal crime.
But how is it enforced? Are they enforcing it a lot? No?
Well, I had a client who had a bag of marijuana on a table in her den, and she was upstairs in the bedroom. And then I guess the next morning, the managers were coming in to repair a leaky sink. So they've given her notice they're going to be there in the morning.
Yeah.
So they come in, find a bag of weed, and they were going to evict her for that.
And what happened?
I believe she had to move.
Even though this was allowed under state
no,
law.
so it's like
We've
screwed up.
made that
That's why-
argument.
This is
But-
why this is also as an aside why Roz and I obviously advocate the giving out of consumption licenses a lot more, because there's nowhere for people to, it's really unfair.
You're not
especially
allowed
in
to
public
smoke it
housing.
in public, so what are you supposed to do if you can't do it at home?
That's why the local governments need to pass consumption laws. And we also, Roz and I, of course, advocate that there would be centers that would not only have cannabis consumption, but there'd be supervised drug use and all sorts of things. But that's for another day.
Okay, well,
We did it?
real quickly, if you have any questions about expungement, you should consult a lawyer. If there's immigration issues, consult the immigration lawyer. And then,
How about for the stuff that you guys do with the housing? Where would be, so that's the California Rural Legal Assistance in Ventura. What do people do in LA when they have these, like if they had issues with housing, that they would, you guys do all this stuff?
there's a bunch of nonprofit organizations in LA County. Western Center for Law and Poverty is one of them. Legal Aid Society. And then I would go contact either local courthouse. Usually they have what they call a self-help center, which does housing and refers people where to go and stuff like that. So,
And if you guys need anything else, obviously you want to hire Roz or I to do any post-conviction relief. We're available to do that. But we've also given you guys a bunch of resources and are happy to continue to try to do things on your own if you can.
all right.
And just as background, how long have you been a criminal lawyer, Bill?
Well, actually, I was a public defender for
Right.
16 years, and now I'm
Yeah.
working for a nonprofit law firm doing the same things, helping low-income communities, and reentry came up with the housing and employment. So,
And how long have you been doing that?
I'd say about over 25 years.
Oh, wow.
Yeah.
And Roz and I have been practicing, as most people probably who are watching us know us like a lot for our cannabis practice, but I've been doing criminal defense for my whole practice, 17 years. And in fact, my first 14 years, that was 95% of my practice. And Raza has been doing it for the past, 10 years?
That's right. I did
Yeah.
civil litigation for a few years before that, and then before that, I worked as an assistant to a federal judge in an appeals court. So I've been in and out of different type of courts for close to 20 years now.
And, you know, of course, now a lot of our practice is regulatory and compliance in the cannabis industry, but we still do, of course, all criminal defense, and it's really important also when you're in the cannabis industry to have an understanding of, you know, can you be licensed? How does your criminal record impact that? And there's things you can do to probably encourage you to be able to be licensed. Unfortunately, the California cannabis licensing is the most
Rigorous.
easy. No, to get into it though. There's all these exceptions. for
You have
versatility.
to have a pretty bad criminal record to get
to be excluded. Yeah, no,
Really?
it's awesome. Yeah. So
Well,
just
that's
as a little
good to
aside
hear.
for California
Mm.
cannabis licensing, a prior any marijuana offense cannot be used against you. Any controlled substance offense really can't be used against you unless you're on probation or parole. So like, unless you had cases involving 3 kilos or more of non-marijuana, you can have gun cases as long as they're, I think, below 20 years old, as well as strikes. So that's the one thing that's pretty cool about the California cannabis licensing is that it's actually really re-enfranchising people who otherwise.
And
were
hopefully
excluded
this will
from
be a
licensing.
start of a nationwide trend on licensing, because licensing is still an area where people are stigmatized and discriminated against just because they are drug users or in the past were drug users.
And actually, that was the whole reason, just as like maybe to end this, but the way that even happened is that licensing was affected by drug use. It was actually when in the 30s when the federal government distinctly used these laws to go against Billie Holiday for just because they were racist fucks. And with Billie Holiday, they actually created this like law that said that you would lose your cabaret license if you had.
There's all kinds of things that need licenses, like
You know.
cosmetology licenses.
But they do it
you
on.
need to-
It was on purpose, so we're trying to reverse that. But it was done on purpose to really disenfranchise minorities. And so all this, that's how the licensing thing came about. And the same thing with this housing. So there's all these collateral consequences. We're all here advocating to try to change that. In the meantime, there's a bunch of legal maneuvers that you can do to try to make yourself able to work in more places, travel in more places, and be licensed. And if anybody has any more questions, you can contact us through Instagram. You can call our office at 323-653-9700. You can go on our website that you guys are already on, margolinlawrence.com, MARGOLINLAWRENCE, and you can chat with us. And good luck, everybody. And we'll be posting some of the paperwork that we talked about today. And we have 2 upcoming webinars. This was our practice, and this was also our free one. We're going to continue to do some free ones, and then we're going to do a couple that are not going to be free, but are going to be very educational. And just look out for them. We have one coming up, DIY license, so how you can do your own cannabis license. And then I think we're going to also have a gun law one that maybe might come up next month before even the DIY license, because right now I know that one thing that's continue to selling is actually cannabis and guns. So, and I know that everybody's very interested and confused about gun laws. So check out that and look out for that next time. And thanks everyone for watching.
Bye.
Stay healthy, everyone.
Yes. Make sure you put alcohol, I guess, on your bongs.